May it please the court. Good afternoon, good morning, Your Honors. My name is Mary Levine. I'm appearing on behalf of the appellants Heritage Foundation, Meals on Wheels, Salvation Army, Shriners Hospital for Children, All Faiths Food Bank, and Easter Seals of Southwest Florida. I would like to reserve 7 minutes for my co-counsel. We're going to divide the argument given the consolidated nature of these appeals. And then we'd like to also reserve 5 minutes for rebuttal.
So you want to do 8, 7, and 5? Is that what you're suggesting?
That would be fine, Your Honor. Yes.
Okay. And co-counsel is going to be arguing for Pace.
That's correct, Your Honor.
Very good.
Yes. The issue before the court this morning is the de novo review of the trial court's interpretation and application of the will reformation statute that is contained in section 733.1061. Both parties have concurred that the court has jurisdiction when the court raised the issue as to whether or not there was jurisdiction with respect to this matter. It is our position that the 2 orders that are at issue are final orders that are reviewable by the court under Rule 9.170B2 and 23. These orders involve the dismissal of the adversary amended petition to revoke or reform the 2009 will. They awarded appellants their attorney's fees and costs in accordance.
Didn't the dismissal precede the fee issue?
It was contained in the same order.
Was it the same order where it recognized that they had voluntarily dismissed or asked for an involuntary dismissal, whatever the wording was? They had requested that their petition be dismissed.
Yes, if you look at the orders appealed, what it says is the first one is that the court agreed to grant their motion to dismiss. That's an unusual thing to file a motion to dismiss your own amended petition. But that was paragraph 1. The second paragraph was to dismiss the amended petition, so that was actually contained in the order itself.
No, I have it.
And the third aspect was the court's determination that appellants were entitled to the fee award and costs per the fee statute, and the court determined the source of payment would be the estate as opposed to any of the sources that were outlined in the fee statute itself.
So oftentimes we get final judgments that do multiple things, as this one does, and then there's a determination of entitlement for fees but reservation of jurisdiction to determine the amount. And typically we do not consider the fee issue because it is not ripe, because fees, the amount has not been determined. Is there anything in the code that says, I know there's a lot of arguments that the code gives broad appellate rights in the context of probate and trust proceedings, and is it your position that this falls within that broad appellate rights scheme?
Yes, I think in the guardianship of Bloom case that was decided by this court basically talked about the fact that Rule 9.170 contains a non-exclusive list. They enumerate 24 categories of matters that can be considered as appealable orders in a probate matter. And so in our view, we believe that Bloom stands for the proposition that what in essence was a denial of appellants' entitlement to recover attorney's fees from the appellees, as the fee statute would suggest as the appropriate interpretation, that it was a denial of an award of fees because it came out of their own money, which was the estate assets.
I don't want to go ahead. I just want to let you know I'm going to give you a couple extra minutes because the jurisdictional issue is something obviously we've raised,
right.
But I don't want you to not have the chance to address the merits of your position before it goes to co-counsel.
Thank you.
Does the fact that there are non-parties who will at least fund effectively some portion of this fee award affect the argument you just made? Right, in other words, your argument was basically because the fees are coming out of our hide, it is a denial of fees as to us, but there are, if I understand the argument in the briefs correctly, there are at least some non-parties that account for 33% of the fees that would be awarded that aren't here, and that's not coming out of your money.
Well, right, Your Honor, but they weren't parties to the action. They were dismissed. They were actually defaulted in the proceedings. And what the fee statute says, it is to be awarded against a party. And so these non-appearing beneficiaries were no longer parties. And so our argument is that it still is inequitable because it reduces the overall assets.
I get your argument on the merits. I'm just wondering if it plays into the jurisdictional argument you just made at all. In other words, you said this is basically an order over which we have jurisdiction because it finally determines that you are not entitled to fees because it makes them payable from somebody else.
I don't think that particular issue goes to the jurisdictional aspect, in my opinion, Your Honor. With respect to the matter of the jurisdictional issue that you raised, we think that the orders are final because the judicial labor was completed. In other words, the court made a final determination that there would be a fee award in accord with the statute. The court dismissed Appellee's amended petition to revoke or reform. That is a final order in and of itself. And in taking that step, coupled with a fee award against the estate, what they did is essentially exonerate the appellees as they were dismissed from the action so that there would be no way for appellants to recover against them. And so it left the appellants in the position where they had no recourse but to seek appeal as regards the source because having had the amended petition dismissed, it dismissed those parties from the action. I would also note that
Of course, if the court enters an order as to the amount that is not satisfactory for any reason, there's an appeal for that as well, right?
well, right, but when you think about it, given the existing order, if the matter were to go back to the trial court right now, the only order that could be awarded for a fee award would be against the estate assets. So, and at this point in time, if we appealed that order, the appellees would no longer be parties to the case. The only appellee who would
You would be a party as a personal representative.
Yes, only appellee Ida Thomas would remain. The other three parties would have been dismissed because their amended petition was dismissed. And presumably, she's the personal representative. She would take the position that the fee award was acceptable against the estate. She wouldn't have any standing to argue that her own individual interests were affected because she individually was a party as well. The other thing I would note is that it's a little bit circular because the amount doesn't matter because if it's against the estate itself, then we would be back to the appeals court to again raise the issue of what is our opinion that the trial court erroneously interpreted and applied the fee statute because we don't believe that the fee statute's language allows for the estate to be a source for payment of the fees. The fee statute states it is to be awarded against a party, their interest in the estate, or a judgment entered against other property of theirs, or both.
If we don't agree with your interpretation of the statute and we conclude that fees would be awardable under subparagraph 1, is it your position that under subparagraph 1 fees could not be awarded against the estate?
Yes, Your Honor, because I think if you look at subparagraph 1, it doesn't talk about sources. All that it says is that fees are to be...
Does the probate code in general provide for fees that can be awarded against an estate?
Only
or
where
the
there's...
case law, I should say, interpreting it.
Yes, Your Honor, but in the circumstance where there's a benefit rendered to the estate, the attempt to the amended petition was intended to revoke or reform the will and change what it said. That wasn't beneficial to the estate given the fact that the 2009 will gave all of the assets to the beneficiaries.
Your view of sub 1, because of the mandatory word shall, is that this is essentially a prevailing parties fee statute, right?
Yes, that's correct. And the reason that I believe that is that when you look at the legislative history, the legislature specifically talks about the fact that chancery or equity would be similar to a prevailing parties attorney's fees provision. And so because the legislative history suggests that that was the intent when the statute was enacted.
Well, then why is as in chancery necessary language at all? I mean, why wouldn't the legislature have just said the court shall award taxable costs, including attorney's fees and guardian ad litem fees? I'm trying to figure out what freight the words as in chancery actions really carries in this statute.
Well, I think that when you think about probate proceedings, generally they're equitable proceedings, and I think that in chancery it gives the court some latitude in terms of the way they fashion the fee award. But I think that if you take subsection 1 to say chancery negates what is actually stated in subsection 2, I don't think that's a normal or reasonable interpretation of the statute. And I don't think that was the intention.
Although this paragraph 2 talks about the court in its discretion may direct payment from these sources, this source or that source or both those sources. And again, your interpretation would change the wording of the statute to be a mandatory, so we don't need the language, the court in its discretion. It would simply say, the court shall direct payment from a party's interest, if any, in the estate, or enter a judgment which may be satisfied from other purposes of the party, or both. So are you saying that the legislature has put a lot of surplusage in both these statutes?
No, Your Honor. What I'm saying is that in subsection 2, I think the may language gives limited discretion. So in other words, I think it says that the award is to be entered against a party or their interest in an estate, because oftentimes when you have these kind of contests regarding what the meaning of a will is, it could be between and among various beneficiaries of a particular will. And so when it talks about a party's interest in the estate, it might be a sibling who claimed that I'm entitled to 50%, not 30%, and that Dad made a mistake in his will. So I think...
I've let you go over because of the jurisdictional amount, but if we're going to reserve 7 minutes for your co-counsel, you have about a minute to wrap this up.
Oh, okay. Thank you, Your Honor. It's our position that the court does have jurisdiction under the bases that I have stated, and that the court did err in terms of awarding fees from the estate, because I don't think that was either the public policy which supported the enactment of this fee statute, which was to deter unfounded and nefarious will contests. So I think that has to be kept in mind together with the legislative history in terms of guiding the court's interpretation and understanding and appropriate application of the statute. Thank you.
Thank you. And by the way, are you all splitting up rebuttal time, or will one of you handle the full rebuttal?
One of us will handle the full rebuttal.
Very good.
Yes.
I'm off to an auspicious start. May it please the court. I am Greer Wells with Gray Robinson in Jacksonville, and we have the pleasure of representing Pace Center for Girls, one of the beneficiaries under Mr. Schmidt's will. We certainly recognize the court's concern on the issue of jurisdiction, and we would concur in the comments made by Ms. Levine on that issue. I think under 9.170 and the various subparagraphs, to us, there has been a petition which determines revocation of probate of a will, denying or granting the motion to dismiss,
which dispute that would be appealable. But as in many contexts, part of an appeal might go forward when a fee issue is dismissed for lack of jurisdiction because the amount has not been awarded. But Unless you have something new to add, I think we understand the position of
Okay.
both counsel on this side as to jurisdiction.
I really don't have anything further to add. I was simply concurring in her position. Thank you, Your Honor. On the merits itself, the comments that the court asked about the language of subsection 2, the court may in its discretion award. I believe, as Ms. Levine also noted, the may in its discretion is giving the court three choices. The parties
How is
interested
that
in
any
this.
different than if the legislature would have said, shall direct payment from this source, that source, or both sources? Why should we read may as shall in this context? When, and in fact, to make it worse for your position, in paragraph 1, the court used shall.
We understand
So
that.
they certainly understand the difference between those two words.
But in subsection 2, they didn't list any other sources. No other sources are listed in either subsection 1 or subsection 2.
And I was trying to kind of fathom a reason for that. I mean, in other words, is it possible? Without this statute, right, would the trial court be able, or would the probate court have the authority to impose an in personam judgment on fees, for fees on a party to a will contest like this?
I think, as Ms. Levine pointed out, and I think we pointed out in the briefs, fees can be awarded if there's been a benefit conferred upon the estate.
Right. I guess what I'm saying is, suppose the statute only had subsection 1 in it and didn't have subsection 2. Would subsection 1 be sufficient authority for the probate court to award an in personam judgment for fees against a party?
I think the court, utilizing just subsection 1, could award fees against any party, or as in some of the cases that have been cited, split fees in some fashion between the parties. But we think because they did do subsection 2 and listed only 3 sources, subsection 2 does not say including but not limited to. There's no non-exclusive listing of other sources from which fees could be paid. The court's discretion is limited to the 3, and you can't read words into the statute that are not there by the legislature.
But isn't that because under 733.1063, and as I think you've already pointed out, any attorney who has rendered services to an estate may be awarded reasonable compensation from the estate. And so under 733.1061, it's an acknowledgement that, but in this situation, here are 2 other possibilities. Why can't they be read together for that proposition?
Because I don't think that the fees can be awarded against the appellants because they've not rendered services. They have not rendered a benefit to the estate in the performance of the petitions to revoke or to reform the wills. The only part...
Giving effect to the testator's intent, I mean, isn't that a benefit to the estate?
But that's exactly what they did not do here.
I'm sorry, the appellees,
The appellants...
Or I'm sorry, the appellants.
The appellants challenged the will.
No, the appellees.
Excuse me, I'm sorry. The appellees...
Right.
Can I sit over here for a while?
Right, they challenged the will, they dismissed it, they don't get fees.
And after 2.5 years of litigation, they filed a consent order for probate of the will and a motion to dismiss their own petitions and conceded that the appellants were entitled to fees. So certainly no benefit was conferred on the estate. There was, contrary to giving effect to the testator's intent, they did just the opposite.
No, but you all.
Is the end result the test as to whether or not a benefit was conferred? Because there are cases where there appears to be some, whether it's wrongdoing, undue influence, mistake, and so forth, where the issue is teed up for the court, discovery takes place, and the court says, no, I think the current version of the will is exactly what was intended. Yes, you had some legitimate concerns because of the history in terms of other wills and trusts and so forth, but doesn't that clarification of, yes, indeed, this was the intent, isn't that a benefit to the estate?
I would disagree with Your Honor respectfully because At the outset of these proceedings, the appellees acknowledged they had no evidence of any basis to revoke the will, except we thought that's what he was going to do. And I think the really telling point is that the paralegal who worked with the attorney who actually prepared the will was known to the person representative for a number of years. After 2.5 years, her deposition was taken, and she confirmed that it was the testator's intent to eliminate these folks as beneficiaries. There was never any evidence to suggest that their action was in fact justified. Although the court noted below in one of the hearings that, you know, maybe they were justified to do it because they thought that the will was wrong because of prior wills, but that is simply not.
And there had been a change in counsel, right? A new attorney had gotten involved for the last will?
I don't think so. I think Mr. Namack did the last two preceding, with 2008 and 2000.
But there had been a series of wills, so he had gotten involved, the last one, the last two, but not the whole string of them, correct?
That's correct.
Okay.
But all of the appellees also acknowledged they had no knowledge of a 2009 will. They were aware of a 2008, but were not aware of what it said. But they filed the action without any factual basis whatsoever. So we find it very hard to understand how there was any benefit conferred upon the estate that would justify not awarding assessing fees against the parties who commenced the action, particularly in light of subsection 2 of 733.1061.
Very good, Mr. Wills. If you can have about another minute, because I gave your colleague a little extra time, and I'll give the other side some extra time if you need it.
Thank you very much, Your Honor. I would like to simply make the observation that an award of fees from the estate in favor of appellants is simply no award at all. We are the only beneficiaries under the estate. The person representative may, of course, be entitled to a person representative's fee, but you certainly can't claim that chancery or equity plays any role in an award from the estate. In conclusion, we request that the court reverse the order to extend and awards fees from the estate and remand with instructions for the court, lower court, to award fees against the parties. Thank you.
Thank you.
Good morning. May it please the court. My name is Kim Bald. I am with the law firm of Harley & Bald, and I'm here with my partner, James Lynch, who helped me with the case. We had the pleasure of representing the petitioners in the case, and we did file, after completing the discovery in this case, we did file the consent and withdrawal of the petition. And, Your Honor, what they're basically asking in this appeal is for this court to rewrite the statute, to ignore what the legislature provided, and to find that Judge Economou abused his discretion despite the numerous factors that were presented to the court at both the January 2018 hearing as well as the hearing on the motion for rehearing that started with the age of the decedent until the conclusion of the case. They argue to this court that Section 733.1061 doesn't authorize any probate court to award fees against an estate. And as Judge Silberman mentioned, that's throughout the probate code, that's exactly what one of the sources for the court. If you look at, and if you compare 733.1061 Pren 1 to 733.106, both provide that the courts, that attorney's fees shall be awarded as in chancery. If you look at Section 4 of 733.106, it says, when those costs are going to be awarded from the estate, this is what the court can do. So it acknowledges and presumes, just like in 733.1061, that is exactly where the estate, what will be the source of the fees, unless the court, in its chancery, equity, jurisdiction, looks at the circumstances of each particular case and finds that that particular case says to do otherwise. And under 732, or 733.1062, it gives the court in its discretion 2 additional pots of money that the court can award the fees on, but it's three different factors or three different words
Before
that...
we go to that, under subsection 1, which says the court shall award taxable costs, this particular statute doesn't say anything about a benefit to the estate. Does there have to be a benefit to the estate for an award of fees under subparagraph 1?
I don't think, Your Honor, it does. We're not asking for fees, obviously.
understand.
The appellee has not asked for fees from the estate. I think in this case, we clearly did show a benefit because there was a clear issue about the language of that will and what it meant.
Paragraph 1 is mandatory, apparently unconditional language that fees shall be awarded in these two types of proceedings and taxable costs. Doesn't say where how it can be awarded, but it seems to be consistent with the rest of the code. It would clearly be awardable against the estate, or at least I would think so. And then your position is, if that's a given, then paragraph 2 says, by the way, there's other sources that you can look to if you're going to award fees or if you have to award fees under the statute.
That's
right?
correct.
Is that,
I think that's how the statute...
and so I'll go back to what I said earlier. Is it your position that whether there's a benefit to the estate or not is an irrelevant inquiry, or is it still a relevant inquiry under paragraph 1 before you even get to 2?
I think it's definitely a relevant inquiry under number 1. I think everything to do with the case has to be a relevant inquiry under
And that's
1.
because it says, similar to shall award taxable costs as in chancery actions, which of course brings in equitable considerations.
That's correct. And I
so
think
the court could still determine that there is no benefit, but I still think looking at the big picture, I'm going to award fees, and paragraph 1 would allow that.
and that may impact what the court finds as to be the reasonable fee that will be awarded. It may actually impact the amount of fee.
Did your adversaries render a benefit to the estate? I mean, they're the party seeking fees, right?
Well, if we, quite frankly, I think we argued throughout all of the problems we had in the discovery and all of the motions for protective order and the numerous hearings that we had to have in order to gain access to the information on the computer. So we were arguing throughout the case that we were the folks trying to determine the intent of Walter SCHMIDT in this 2009 document.
So is the answer to my question no, your adversaries did not render a benefit to the estate?
We don't think they did because of the efforts that they made to, I mean, it would have been a lot shorter case had they not filed the motions for protective order, filed the objections. It would have been a lot quicker case to get to those documents, to be able to take the deposition of the paralegal and to find the testimony of the paralegal who I would respectfully submit, she actually said that she's the one that drafted the will, not the lawyer. So it would have been a lot shorter. That will, it would impact, I think, under the equity jurisdiction of the court, the reasonableness and what would be awarded, but I do think under number 1, the court has to award fees.
Assume for the moment that I disagreed with you that other provisions of the code would authorize an award of fees from the estate in these circumstances. On the text of 733, 1061 standing alone, how do you get to that coming from the estate?
I think the only source that would be before the court under 733.1 would be the estate. The court doesn't have, Your Honor asked that question to the appellants. The court, without 2, doesn't have the ability to enter an in personam judgment against the parties on property other than what they would have in the estate. And this is an in rem, we're in an in rem proceeding. The court has in rem jurisdiction, and without Section 2, the court would not have jurisdiction to enter an award of attorney's fees against individuals other than what their interest might be in the estate.
And assume I agree with you about that, but sub 2 still says that the court may do two things. It has a choice to do 2 things, right? And it addresses what those 2 things are: direct payment from a party share or direct payment from the other property of a party. Okay. And it doesn't say anything else. So why kind of under, either whether you call it the omitted case canon or just basically the notion that the legislature addresses what it addresses and doesn't address what it doesn't address, why wouldn't we say those two options are exclusive?
Because I think Your Honor pointed out, shall was used in number 1. The legislature did not give the probate court discretion under number 1, other than the equity powers.
Number one doesn't give the probate court more than one choice. Here, in sub 2, the probate court has two choices.
I think
property of the party or share of the estate.
I would submit under 2 it has 3. It has the estate, as in all of the other trust or other probate provisions, such as 733(1).
Interest in the estate.
The interest in the estate, it has that. But number 2 also gives it 2 additional options. And the second option is the one that allows it to go outside of the estate proceeding and actually enter an in personam judgment against their property. Otherwise, and so I think under the statute, under both 733-1061 as well as 733-106, the probate court has the estate, the person's interest in the estate, and then the separate property.
I think Judge Solario is asking a question similar to what I asked earlier, which is under what statutory scheme does the court have authority to award fees against the estate corpus under subparagraph 1?
I think that is the only corpus before the court to award fees would be the estate.
Does the fact that it says, shall award taxable costs as in chancery actions, is there anything in the statutory scheme that says, for purposes of analyzing what is a chancery action in the context of probate, that would include recovering fees against the corpus of the estate?
Your Honor, I think you have to presume it from the way the other statutes read. Again, 733-106, when it has the same language in the beginning, and it says, in all probate proceedings, courts shall be awarded as in chancery actions. And then under 4, if costs are to be paid from the estate under this section, so it's presuming that is the corpus that the court shall award the fees under.
But this statute doesn't refer to 106.
It's the same. Section 733-1061 is very, very similar to 733-106.
Except it doesn't reference the estate, whereas 106 does.
But I think when you read number 4, it's saying when it's awarded against the estate, which would be under 1. I mean, I don't think you need to have under paragraph 1 of 733-106 or 733.1061 the language in there that's from the estate, because that's the only corpus before the court.
Well, but I mean, then why wouldn't the legislature say so? I mean, it just seems using the phrase as in chancery actions is an awful clunky way to express that the corpus of the estate is available as a source for these fees for 2 reasons. 1, it doesn't clearly say that. And 2, if what the legislature was intending to address was source, it's got a separate provision that deals explicitly with source that doesn't say estate corpus. Your brief, I think, takes the position that the comparison to chancery actions is to give the probate court discretion in fashioning it. I mean, one way I might make sense of the phrase in chancery actions is to say, listen, at an action at law under prevailing party statute, if a party prevails on any significant issue in the litigation, they get all their fees except for claims that aren't inextricably intertwined. Here, why wouldn't the phrase in chancery actions just mean the court has got discretion to say, well, listen, you've kind of prevailed on this part, but not so much this part, and I'm just going to kind of, work it in a way that seems fair.
And I think the court can. I think chancery allows the court, again, all the cases that we cite in the brief talk about under the circumstances of this particular case. The court, under its chancery, it looks at the facts of each individual case. And it does give, under both statutes, the court great discretion to fashion a remedy based upon the facts that are before the trial court, which is what occurred here.
As I understand the argument that you're proposing is 106 is a broad probate proceeding statutory fee scheme. And it says in all probate proceedings, the cost may be awarded as in chancery. And then 4, if it's to be paid from the estate. And then 106.1 deals with a particular set of problems for reformation and mistake. And that paragraph 1 ties back into 106, or has the authority that 106 creates. And then subparagraph 2 carves out, or I should say carves out, expands the sources from which fees can be paid. Am I following your
Yes, Your
argument?
Honor.
Okay.
Yes, Your Honor.
I wanted to make sure that I had that correctly.
And again, we have to recognize that, we're in probate. This is an interim proceeding. And what is before the court is the party's interest in the estate. So clearly the statutes impact that. Your Honor, we cited in our briefs the Atkins case, the Snyder case, and the Schroeder case that talk about the court's equity jurisdiction and chancery rights, or chancery jurisdiction, and how, again, they fashion the remedy based upon the facts of the particular case, and that was very important, obviously, in this particular case. As I argued, what they're asking this court is basically to ignore 3 words. They want the court to ignore the chancery in paragraph 1, they want the court to ignore the may in paragraph 2, and they want the court to ignore that in the court's discretion. And what they're in essence asking this court is to say that without showing any abuse of discretion, that Judge Economou, who heard this case and heard the facts and was presented the evidence, somehow abused his discretion. And that's really what we think this case is. And they have failed in their brief. They've not mentioned it today. Any abuse of discretion by Judge Economou. I actually yesterday went through the transcript and just identified the numerous facts that were presented to Judge Economou when he made his ruling. And he said he was making this ruling following his chancery jurisdiction, his equity jurisdiction, on the totality of the facts in the case. And we submit that under the statute as clearly written, under the words as the legislator put in the statute, the trial court had the jurisdiction and properly exercised its equity jurisdiction to determine that the attorney's fees should be paid from the estate. The court properly exercised its equity jurisdiction and ruled that should not be borne by the individual property. I think they were primarily looking at Ida Schmid Thomas. And the court entered its order, which we would respectfully submit and ask this court to affirm. Thank you.
Thank you, Ms. Holt.
Did Your Honor have any questions on the jurisdiction? I know we did.
I know you agree with the other side that we ought to exercise jurisdiction.
Yes.
We have.
We almost asked. Thank you.
Your Honors, what appellees are requesting is that you allow the trial court to basically judicially amend the statute. I think that you all have...
Is there a reasonable way to reconcile 106 and 106.1 in the manner that Ms. Bald says? Is there no legal way to get there? Is that what your position is?
Well, I think you have to look at the 2 statutes, and the language is different. And so, and I think...
But 106 it seems to me to be sort of a broad capture-all, that in a probate proceeding, costs may be awarded. If costs and fees are to be paid from under the estate, under this section or some other sections, the court in its discretion may direct from what part of the estate. Then 106.1 creates what I think arguably is a subcategory, that in these special kinds of proceedings where it's mistake or reformation, the court doesn't have the same breadth as to whether or not to award fees, but in fact the court shall award fees. And so under 1, if you tie that back into under subparagraph 1 of 106.1, it seems to correlate with 106, except now it's not you may award fees, you have to award fees for these types of proceedings. And then 106.1.2 says, and by the way, if you're going to, here are some other sources you can look at in addition to what is generally provided, which is the estate. Why is that an unreasonable statutory construction?
Because, Your Honor, it doesn't say that in 733, 1061-2. It doesn't, because that statute specifically identifies particular sources, and it doesn't include the estate.
But it does so with language of discretion.
I know,
Whereas
but
paragraph 1 is, subparagraph 1 seems to fit neatly into 106, which 106 says you can award fees, you can award it against the estate. 106.1 says in two particular types of actions, you have to award fees.
I agree.
And so then 106.1.2 says, and if you're going to award fees, here are other ways you can do this. I mean, it doesn't seem to be that the appellee's position is an unreasonable interpretation. And so that's why I'm asking you, is there any way you can argue, no, that is totally wrong, no way you can really get there in light of the language of 106.1?
Well, the position that appellees are taking basically contradicts the entire fee statute that pertains to will reformation. I mean, they're basically saying, yes, we can contest a will, we can seek to reform a will, and if we lose, then we're not going to suffer any consequence. And that is not the purpose of it. That,
Well, in your view, did you confer a benefit on the estate?
pardon me?
Did you confer a benefit on the estate?
Did we?
Did your
Our parties defended their position as beneficiaries under the estate. And to say that we conferred a benefit and then reduce the ultimate award under the estate seems counterintuitive. It doesn't make sense that that would be.
I don't think you actually answered Judge Salario's question, which is, do you think that you did confer a benefit on the estate?
We conferred a benefit in that we defended the will, yes. But the issue is whether or not appellee's actions, because the fee award is, Judge Economou agreed that we were entitled to a fee award in defending the action against the failed effort by appellees to reform and revoke the will. And I think that is the issue that can't be overlooked. That the legislative history talks about Chancery being similar to a prevailing party's fee award. And I think that that circles back to the fact that the fee award has to be mandatory, and that subsection 2 specifically focuses the court on where it should look when rendering the fee award. So that is what we see. And with respect to this issue about the protracted nature of the case, let me be clear that the discovery that was conducted by appellees was deemed by the trial court to be inappropriate. It was a fishing expedition, and he granted our motion for protective order because he found that the things that they wanted to do were improper. And with respect to the Odom deposition, they delayed till the very end of the case taking Ms. Odom's deposition, and she was a named notary on both of the wills.
Of course, your side could have taken her deposition as well, couldn't they?
We endeavored to contact her. We tried to contact her. We couldn't get her to respond. She lived in Alabama. We tried very hard to reach out to Ms.
So they
Odom.
should have done a better job than your side did to try and find her quicker, is what you're saying?
Well, I mean, to the extent that it was their claim that the will was somehow, that there were mistakes.
You're defending the estate. Wouldn't you want to depose the person who might be most intimately involved with the preparation of the last will that you're saying you want to defend?
We did want to depose her, and we did try to reach her.
Both parties had some discovery issues.
Yes.
And the court recognized that, correct?
Yes.
And he granted some protective orders, and he denied some protective orders.
He didn't deny any protective
Well, he
orders.
let discovery go forward. He didn't stop, he didn't say this case is done, let's just get it for trial, there's been too much discovery, you're abusing the process, or you're not doing enough. I mean, the court didn't get to that point, did it?
No, it did not, Your Honor.
Okay. Anything else? You still have a minute if you want to wrap up.
Yes, Your Honor. It is our position that the interpretation of the statute that is urged by appellees is contrary to the plain language of the statute. We agree that the fee award was mandatory, but We think that under the circumstances and all of the factors that were considered by the court, that the determination of whether a party is a personal representative or took care of the decedent prior to death, those were not the sort of factors that were to be considered. The statute talks about determining whether the court should look at the interests of a party and the estate or other property or both. It doesn't talk about those types of factors. And so we would request that the court reverse the trial court's order and remand the proceedings back for further proceedings.
Very good. Counsel,
Thank you.
thank you. You all did